otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Koehler, and in today's episode, I have the pleasure to welcome Colby Smith. Colby is a litigation partner in the Washington, D.C. office of Debevoise Plimpton and is the co-chair of the firm's Securities Litigation Practice, where his areas of expertise focus on SEC and other regulatory enforcement actions, including those arising under the Foreign Corrupt Practices Act. Welcome, Colby.
Thanks, Mike. I'm happy to be here.
Today, Colby and I are going to have a conversation, if you will, about some SEC-specific issues that often arise in the FCPA context, including the prominence of the SEC's disgorgement remedy in FCPA enforcement actions, as well as some other settlement issues that often arise in SEC FCPA enforcement actions. Even though the SEC is only a civil law enforcement agency, and thus its sticks may be a less sharp or less big than the DOJ's, that doesn't mean that there are also not interesting and sometimes disputed issues when it comes to SEC FCPA enforcement. So we're going to start by talking about the disgorgement remedy that is frequently sought by the SEC and FCPA enforcement actions. If you take a look at the actual FCPA statute, while it has specific fine and penalty amounts, you will not see a disgorgement remedy mentioned in the FCPA statute. Indeed, for most of the FCPA's history, the SEC did not seek a disgorgement remedy in FCPA cases, but began doing so in approximately 2004. And as I already mentioned, in the new era of FCPA enforcement, disgorgement comprises approximately 90% of SEC settlement amounts in any given particular year. So, Colby, what do you think of the SEC seeking disgorgement in FCPA enforcement actions, and why do you think it's become such a prominent fixture of SEC enforcement?
Well, Mike, it's a great topic, and as you know, disgorgement has long been a traditional equitable remedy that the SEC has turned to in the full range of its cases. It's not just an FCPA remedy that they seek, but they seek it in other kinds of actions and other cases that they bring, and it has been around. I don't know how long. I don't know what the first time is that the SEC used the remedy in any of its cases, but it's available to the SEC through equity. And the theory of the remedy is to deprive a person or a company of the benefit of an illicit bargain and to restore the money that resulted from that illicit bargain back to those who got hurt by it. At least that's kind of the traditional view of the remedy in equity. And if you think about it in the traditional fraud context, the remedy makes a lot of sense. It's designed to force the wrongdoers to give back to the people they wronged the things that they took from them. And, you know, in the ordinary corporate context, for example, the remedy can be used to give back to shareholders money that was illicitly taken from them. And so it makes a lot of sense to use that remedy in the traditional context of corporate fraud and other kinds of issues that the SEC deals with. It's interesting, though, because the SEC also often, even though it uses that remedy, takes the money into the Treasury rather than giving the money back to shareholders. And that's one of the anomalies about the way that the SEC has traditionally used the remedy and about the way that it uses the remedy in the FCPA context. As you alluded to, the first time that the SEC used the remedy in the FCPA context was in the ABB settlement, which was back in 2004. And if you remember what that case was about, there were a couple of ABB subsidiaries that had made payments to secure some pretty lucrative contracts in Nigeria and Angola and Kazakhstan. And according to the complaint that the SEC filed in the case, ABB had made a little more than $5 million in profits from those projects. And so the SEC decided that it would seek disgorgement of that amount with the addition of prejudgment interest. So the total amount came to about $5.9 million to cover the ill-gotten gains that the SEC found had been made in that case. And interestingly, ABB was a case where there also was criminal action brought by the DOJ, and this is kind of one of the features of the way that the disgorgement remedy has been used over the years. The DOJ in ABB got a $10.5 million criminal fine, which is at that time was a vast amount of money. It's a paltry sum under the FCPA these days. And the SEC counted that $10.5 million criminal payment towards the civil penalty they said they otherwise would have sought. So the only money, the additional money that the SEC garnered in that settlement was the $5.9 million disgorgement remedy. I'm not really sure why they decided to start using that remedy in the ABB case. As you said, they hadn't used it before. And you would have thought they would use it in these kind of cases because in some respects the shareholders are deprived of the benefit of those funds when they're used in an illicit way. But I think it's interesting and important that in ABB the Commission described the profits that were made and tied the disgorgement remedy to those profits. Mm-hmm. And the remedy then has featured prominently, I think, in SEC resolutions ever since. And one reason is that the remedy is uniquely available to the SEC in civil cases. It's not available to the DOJ in criminal prosecutions because in order for it to be available, it would have to be referenced in the statute, and it's not. And over the years, as happened in ABB, the SEC and the DOJ seem to have developed some kind of a tacit understanding, at least, that the DOJ will seek the penalty in these cases, and the SEC will seek the additional disgorgement remedy. And so there's a little bit of I won't call it a division of labor, but a division of penalizing that the agencies seem to abide by. And you very often see that repeated in the resolutions of cases.
Yeah, and you've hinted at, and rightly so, that when it comes to issuers, many, but not all FCPA enforcement actions against issuers include both a DOJ component and an SEC component. And one of the controversial aspects when it comes to disgorgement in these dual prosecution cases is what sometimes has been referred to as double dipping, for lack of a better term perhaps, the notion that the company is paying the improper gain first to the SEC by way of a disgorgement remedy, and then because the net financial gain is one of the most important factors under the sentencing guidelines for calculating the criminal settlement amount, it could be said that the company is also paying that same pot of money to the Department of Justice. Do you see this as double dipping, and if so, problematic in the sense that issuers end up paying more to resolve FCPA enforcement actions than non-issuers?
Well, first of all, I certainly see it as double dipping in exactly the way that you describe. But I'm not sure how objectionable it is at the end of the day. I mean, the criminal law is fraught with situations where people pay multiples of what they earn, multiples of what they gain through the improper activity. I mean, you see that insider trading cases where the typical remedy is 2 or 3 times the profits that are made. You see it in antitrust cases where the typical remedy is 3 times the amount of money that is earned. So I guess as a matter of principle, you may view it as kind of a double whammy to the shareholders, who unfortunately are the ones who both made the bribe payments, obviously without knowing that management was doing that, but also end up then paying the penalty. So there is at least a sense that maybe the shareholders are being treated unjustly as a result of the double dipping. But at least in terms of the criminal law trying to do 2 things, both deprive people of the benefit of an illicit bargain, but also to make sure that they get punished for their wrongdoing, I guess the principle of double dipping probably isn't that foreign to the law. And it makes sense. If you only deprive people of the benefit of the bargain, you might raise the question of how seriously you have deterred the misconduct. And I could see an argument being made that in order to really deter it, you need to not only make sure that the benefit of the bargain is gone, but that there's some additional punishment overlaid on top of that.
And even, in this modern era where so many other countries are beginning to aggressively enforce their bribery and corruption laws, I guess theoretically it's not so much a disgorgement issue, but you can get situations in which there might be triple dipping because a foreign law enforcement agency may be going after, fine and penalty amounts and even disgorgement amounts perhaps.
Well, and I guess in some odd sort of way, what you hope for in those circumstances where you have multi-jurisdictional investigations and resolutions going on is that there will be some coordination among the agencies so that you minimize unjust punishments or unjust resolutions. And I do think that you've seen that kind of coordination taking place, and you've seen kind of agencies giving credit for payments that are made in other jurisdictions and crediting that towards the amount that otherwise might have been due. You saw that, I think, in the VimpelCom resolution that recently was announced, where credit was given for the payment to the Dutch authorities. I think you saw some of that in Siemens as well, where credit was given for payment to the German authorities in that case. So I think there is some benefit from the coordination among the agencies that hopefully help to address that potential problem.
Yeah, and indeed the OECD convention calls on member states to sort of coordinate this and so that it does not mushroom in a way that may deprive the wrongdoer of due process or things like that. And as you rightly note, we have seen some examples of that most recently in VimpelCom and some of the other enforcement actions you mentioned. One can only imagine perhaps some of the the turf wars. There was some discussion of this in the BAE case. Who's the appropriate jurisdiction to take this money and that money. So it's really an interesting dynamic that I think will continue going forward. Now, another thing I'd like to talk about when it comes to disgorgement, and another, in the minds of some controversial aspect of disgorgement, is, as you mentioned, disgorgement is an equitable remedy that seeks to require the wrongdoer to relinquish, ill-gotten gain. And that definitely has some, intuitive appeal in SEC enforcement actions which charge or find, given that many of these actions now are through administrative cease and desist orders, find or charge violations of the anti-bribery provision. However, we've seen very frequent use of an SEC disgorgement remedy in situations in which the SEC, only charges books and records or internal controls violations, something some of your Debevoise colleagues have called no charged bribery disgorgement. And all sophisticated observers know that sometimes the actual findings or the actual charges in FCPA enforcement actions may not necessarily strictly be based on the facts or the law, but sometimes cooperation and voluntary disclosure and some of the other give and takes in the negotiation process. But be that as it may, do you think that disgorgement is an appropriate remedy when the SEC merely charges or merely fines not anti-bribery violations, but just books and records and or internal controls violations?
Well, I agree with you that we have seen cases where disgorgement is sought by the SEC, even though bribery hasn't been among the things that have been charged. And my own view is that as a philosophical matter, in that particular context, disgorgement doesn't really make a lot of sense. I mean, if you think about a books and records or an internal controls violation, those are limited to misrecording accounting entries on the company's books or a failure to put adequate controls in place to protect against or detect improper payments. But it's really difficult to understand how those kind of violations would result in ill-gotten gains that would need to be disgorged. And you would think that ill-gotten gains really could only arise in the context of bribe payments, and that without those payments, disgorgement seems like an incongruous remedy. But as you observed, it's hard to know. I know we all look at these settled orders and go over with them with a fine-tooth comb to understand what their implications and meaning may be. But at the end of the day, these are settled orders. They're negotiated documents. And I do think that produces anomalous results, and as a result may create some uncertainty among those who need to try to comply with the law and to follow the law about exactly how they can do it. A good example of a recent case is the resolution with Novartis, which came out earlier in March. And there it was a case where there was disgorgement for a books and records violation. There was no bribery charged in that particular circumstance. But if you read the order, it reads like an order where bribery was charged. It seems as if the SEC staff, had thought that some bribes had been paid. They said in the order that there were cash value gifts made. They were made in exchange for a certain number of prescriptions made by doctors in China. The order talks about travel that was provided in exchange for prescriptions. So it certainly reads as if there might have been a quid pro quo, and that reads a lot like a bribery allegation. The SEC even concluded that these gifts had led to millions of dollars of additional sales in China. So they even seem to tie what happened to profitability. But again, they only charged books and records violations. You would wonder why they even needed all of those allegations in order to justify the books and records and internal controls charges that they did make. So even though there was no bribe charged in that case, it seems pretty clear that the SEC staff at least felt that some improper payments had been made and that maybe that justified the disgorgement remedy. But I think it is intellectually inconsistent to impose that kind of remedy where you can't charge the bribery charge, and one wonders why they didn't opt then for a penalty. In that case, they could have charged the same amount as the penalty as they got in disgorgement, rather than using the disgorgement remedy. And I think we just don't know why that happened. I would hope that in cases like those, that as they come up for review by the Commission, that the Commission's Office of General Counsel is at least asking why, in those kind of cases, they are imposing a disgorgement remedy rather than a penalty, just for the sake of consistency and clear guidance to the issuers.
As most knowledgeable observers recognize, there's a lot of give and take in this negotiation process. A lot of this is, not very transparent to the public. But I've sort of always taken the position that the SEC, or if we're talking about the DOJ for that matter, really has like a duty to defend what they make of the enforcement record. They have a duty to defend what they choose and perhaps not choose to put in those resolution documents that are made public. And as you know, when you do have these situations that only charge or find books and records and internal control violations, it is really an open question whether disgorgement is an appropriate remedy in those cases. We know that, at least to my knowledge, no issuer has ever challenged, in terms of the litigated proceeding, the SEC in an FCPA enforcement action, but that doesn't mean that people like you or I can't speculate as to perhaps what might happen if a federal court judge was faced with a disgorgement remedy and merely a books or records or internal controls case. Even taking this a step further, and I don't know if you feel that this would, I guess, be more concerning or just equally concerning, but even now that the SEC is using non-prosecution and deferred prosecution agreements, there have been situations in which the SEC has used an NPA in an FCPA enforcement action. And there, even though the company was not charged with anything, the SEC still sought a disgorgement remedy in that case. I'm referring to the Ralph Lauren case. Any thoughts on the NPA aspect of this?
Well, I think, and obviously those kind of resolutions are negotiated in just the same way that that others are. If you're getting a non-prosecution agreement and yet you're paying a penalty, it's pretty clear you didn't get a declination from them. And so in the absence of a declination where they're getting something, it's clear that it's a product of a negotiation. And it's hard to know, it's hard to look behind to see what what may have gone on in the background during the course of the negotiations to make that the right outcome. Again, I hope within the Commission that people are paying attention to this. I agree with you that it's important for the Commission and the Commission staff to approach these cases in a consistent and rigorous sort of way. And I will say that in negotiations that I've had with the Commission staff, in general, you find the staff are receptive to those kind of arguments. When you come and say to them that as a matter of enforcement policy, as a matter of consistency, the way they're trying to propose that the case be resolved doesn't make sense. If you're persuasive enough, at least, often they will say, I think you're right, so we need to change the way that we're approaching this resolution. So I don't mean to suggest that the SEC isn't receptive to those kinds of arguments, but it's a little bit hard to get behind the veil, I guess, in some of these resolutions that come out and seem a little bit anomalous to understand exactly what all the considerations were that went into them.
Another issue when it comes to disgorgement that I think is really interesting, and by posing this question, I'm not at all condoning companies that engage in, allegations of bribery or anything of that matter, nor am I really even suggesting that this question is relevant to legal liability under the FCPA's anti-bribery provisions, but I think the next question is very much relevant to the disgorgement remedy, given that it is an equitable remedy, and that's sort of the following. The vast, vast majority of FCPA enforcement actions are against well-known, otherwise well-respected companies that are generally viewed as selling the best products for the best prices, and in many cases is selling those same products to, for instance, the U.S. government. Very, very few enforcement actions contain any allegations, suggestions, inferences that somehow the product was compromised or that the product was inferior. So in those type of enforcement actions, and again, this is not meant to excuse liability, it's just meant to focus on disgorgement and whether it's a profitable, equitable remedy in those cases. If we were being honest, I think, there's probably any number of reasons why pharmaceutical company A, B, or C sold its drugs in China, not just because Chinese officials visited Disneyland or some of those other allegations. Do you think with those types of companies, the notion that the company probably would have got the business anyway should somehow be relevant to the disgorgement remedy, either as a matter of law or just as a matter of principle, thinking about it?
Well, I guess I'm a little bit skeptical, and the reason I say that is that whenever you find, or whenever the government finds that an illicit payment was made, it probably is a fair inference for the government to draw that somebody within the organization, within the company, thought that the payment was an important part of getting or maintaining the business. So I think the government at least has a basis for drawing the inference that it draws, and maybe we'll never know whether the company would have gotten that business anyway just because of the quality of its products. But my questions about the use of disgorgement kind of as a general remedy, even in situations where bribe payments have been made, are a little bit different. One question that comes up in cases that I've done is, what does the commission do where the payments actually didn't result in a profit for the company?
Right.
I mean, there are a remarkable number of situations or projects where you see illicit payments being made in order to obtain the business, but because other contractors, other bidders are themselves getting the business, not because they're the most competent, but because they have paid some money, you find a lot of incompetence in these projects, and very often you find that the projects just never come to fruition. They never get fully executed, and the profits that someone expected or hoped they would get from the project, they just never come about. I can't tell you how many docks around the world are filled with equipment that got shipped for projects and never got paid for. And so it's a curiosity, what does the commission do in situations where no profits were earned? Does that mean they should walk away from the disgorgement remedy? And I think you could make a strong argument that they should, but very often what we see in those cases is that the commission doesn't refer to profits anymore in the orders. They start talking about revenues that would not otherwise have been earned. Sometimes they'll talk about the amount of the bribe payments that were made on the theory that, well, the payments in that amount never would have been made if there wasn't some expectation of at least earning that much money back. But I think there's some serious questions about the application of that remedy in situations where profits weren't earned. But I think we see cases where the commission staff still presses ahead with that remedy. So
yeah, this is just my own observation here, probably consistent with what we're seeing in the FCPA space and related spaces generally, and that's just the creeping expansion of theories of liability, of theories of recovery. It seems to be that the government says, well, I got this remedy in this type of case without too much problem, therefore it must be a viable remedy, and I'll do it again, and I'll do it again. If someone is upset about this, surely someone will contest this. But as you well know, given the clients you represent, a lot of times the decision to resolve an SEC enforcement action in the FCPA context and other contexts sometimes is just risk aversion.
Yep, fully agree. And sometimes as I say, you'll make these arguments to the staff. Very often the staff are receptive to them, they understand them, and they can switch gears. They have plenty of different remedies at their disposal. They can charge a penalty as easily as they can charge disgorgement. And so, you make these arguments. Usually I think people are understanding of them. In other circumstances, especially I think in circumstances a little bit like at least my reading of the Novartis order, where the staff has kind of reached a conclusion that they think illicit payments were made, even though they're not charging that violation for whatever reason, they still feel free to seek some disgorgement for the uncharged charge.
Yeah, I know it is interesting. And the final question I have for you, you mentioned the word consistency several times during our conversation here. And one thing that drives me crazy when I read FCPA enforcement actions, among other things, is really the lack of consistency when it comes to SEC settlement amounts. You have similar cases based on similar facts, based upon similar charges, but yet you have some of those SEC enforcement actions. They include sort of the trifecta of the civil penalty, the disgorgement, and the prejudgment interest. Other enforcement actions only include disgorgement and prejudgment interest, whereas yet other enforcement actions only include a settlement amount. Any insight into the process there and why there really is a lack of consistency concerning the specific components of the settlement amount?
Well, the only observation I have there, and I get two things. First of all, the disgorgement and prejudgment interest usually go together.
True, right.
The prejudgment interest is usually charged on the disgorgement amount, not on the penalty amount.
Correct.
So it's kind of two options that they have, both of the remedies or one or the other of those. And I do think the one pattern, I guess, that I've been able to see that seems pretty clear to me is that in situations where you have a joint prosecution by the DOJ and the SEC, as I said earlier, there seems to be some kind of a tacit agreement among them that the DOJ will focus on the penalty aspect and the SEC will focus on the disgorgement aspect. And I think they may feel like there's less of an opportunity for double dipping in those circumstances, although I'm not sure they completely do away with the double dipping. But it may feel like it's a little bit more balanced to do it that way. So that at least I think explains in some situations why the SEC order may lack the civil penalty element. But I'm not sure that it explains it in every case. And so in some cases I do think that it remains a little bit of a mystery why they come out the way they do. And I do think it would be beneficial if the staff were thinking about the consistency of the orders when they negotiate these resolutions. I think it would just be beneficial to those who want to understand what their obligations and risks are.
Yeah, good advice. And thank you for joining us today. I'll sort of end with how I began. Even though the SEC only has civil enforcement in this area, that doesn't mean that even in this arena there are not some, disputed, contested, controversial aspects with SEC, FCPA enforcement, including our specific topic we've been talking about here, and that's disgorgement. And really any company, any issuer under FCPA scrutiny needs to have, lawyers that are well-versed in these issues. And you and your law firm are clearly one of the leaders in this area, so I thank you for taking the time to speak to the audience on FCPA Flash.
Thank you, Mike. It's my pleasure.